offence. But more recently, we had the ridiculous situation where Westminster City Council told Tate Britain to get an entertainment licence for Susan Phillips' Turner Prize-winning sound installation. Ms Phillips's prize-winning exhibit features a recording of her singing Lowlands Away, a traditional folk song played through 2 loudspeakers. Westminster's legal department ruled that the Act's incidental music exemption could not apply in this case. Even more absurdly, the Morris dancing exemption under the Act could have offered Tate Britain an intriguing way round Westminster's licensing requirement. It allows unamplified loud music if it is an integral part of a performance of Morris dancing or similar nature. If Susan Phillips herself or another vocalist were to sing Lowlands Away unamplified in the gallery to some Morris dancing or dancing of a similar nature, then this should be exempt. And of course that was entirely her choice. So, as we can see, the Act has had the effect of criminalising the showing of a prize-winning piece of art by one of the world's leading art institutions, a range of musical and other performances, and the provision of facilities for them that could not conceivably produce antisocial levels of noise. And, my lords, I could come up with a myriad of examples of the idiocies of the Act. But contrast that with that position with the freedom to show large-screen broadcasts of football matches in pubs without a licence under this legislation, because that form of entertainment is explicitly exempt. And in addition, my lords, think how many premises have permission for a DJ but not for live music. At the end of 2009, a very effective demonstration in aid of live music was held by the MU and Equity in Parliament Square. The demonstration coincided with a full debate on the Select Committee's report held in Westminster Hall. At that point, the previous government suddenly seemed to wake up and make proposals for an exemption of 100 capacity. They launched yet another consultation on this issue close to the general election, when they had absolutely no hope of implementing any proposals. And Mr Fergal Sharkey, the CEO of UK Music, the umbrella organisation that represents a very large proportion of the music industry and strongly backs deregulation for live music, calculated that there had now been 9 consultations, 2 government research projects, 2 national review processes and a parliamentary select committee report, and yet, my lords, still no action. My lords, the desire to nurture creativity, cut back bureaucracy, save costs for small venue owners and eliminate the inconsistencies and absurdities of the Licensing Act explains why I am once again bringing forward today a private member's live music bill. Now, my lords, this is somewhat different from the previous version, but I hope that this one is even more effective than the previous bill I introduced this time last year. My live music bill amends the Licensing Act 2003 in 5 main respects. An exemption for live music in small venues for audiences up to 200, which are licensed under the Licensing Act 2003. And this exemption is conditional on a new Section 177, which could be triggered to review a licence and make live music in that venue licensable if complaints by local residents are made. The Live Music Bill has the effect of reinforcing the rights of residents by allowing conditions to be placed on the premises licences following complaints upheld under the Environmental Protection Act 1990. Unamplified live music is exempted anywhere between 8 AM and midnight on the same day, but this can be disapplied in alcohol licensed premises if complaints are upheld. Conditions could then be applied. A broad exemption is introduced to any premises not already licensed under the Act, but qualifying as a workplace for the purpose of health and safety legislation. And this covers not only hospitals, schools, etc., but factories, offices and any places covered by the workplace definition. And this is an important new addition to the bill. And then we have the removal of the entertainment facilities provisions altogether. There would no longer be a requirement separately to authorise the provision of musical instruments, such as a piano, for example, for a school concert open to the public. And then there's a new exemption which allows live and recorded music to accompany Morris dancing under the bill. which I'm sure my noble friend Lord Breasdale will approve of. The rationale for this approach is as follows. The Licensing Act 2003 creates and regulates the free licensable activities, supply, sale of alcohol, regulated entertainment and provision of late-night refreshment, subject to the operating schedule which forms part of every premises licence issued. Live music is classified as regulated entertainment under the Act, and therefore, without an exemption, small premises are bound by the same legislative burden and costs as larger premises in relation to being able to have and provide live music, which can be disproportionately prohibitive. The Licensing Act 2003 created as a safeguard to residents and other parties who are subject to noise and other disturbance the review process, and the Live Music Bill preserves this right, as I've mentioned, for residents and businesses in the vicinity of licensed premises, and explicitly allows for the exemption to be removed in circumstances where premises operating under the small venues exemption are found to undermine the licensing objective of prevention of public nuisance. My Lords, a further exemption for unamplified music at venues of any size, regardless whether they possess a licence or not again, is a proportionate solution, as it allows, for example, cafes to put on such entertainment without the cost of applying for a full licence. And the final exemption for hospitals, schools and colleges would permit such institutions to host live music entertainment without the additional cost and administrative burden of a licence, but subject to a reasonable limit on the number of people attending. My Lords, my own proposals are not yet set in stone if the bill can be amended as it moves through the stages in this House. But let us remember that the Select Committee recommended that the appropriate figure was 200, and this figure is backed by the MU, Equity, UK Music and the Incorporated Society of Musicians. I do look forward to the debate on this bill in this House, and I very much hope that the government will support it, and that we hear some encouraging words from the noble Baroness, the Minister, at the end of today's debate. The pub trade are particularly concerned about the health of live music. There are 39 pubs, I believe, closing every week. This form of live music exemption could give a great boost to the economy of the pubs, and I do commend my honourable friend Mike Weatherly's Rock the House campaign, which will set up competitions in constituencies right across the country in live music. And maybe, my Lords, we should also add to that, after the last debate, a competition to see who can find the pop songs with dog in them as many times as possible. My Lords, I hope that the government will respond positively today. I'm delighted that we have so many speakers in today's debate. In particular, I look forward to the maiden speech of my noble friends Lord Grade and Lady Randerson, and I'm delighted that they're taking part in the debate today. I beg to move.